Good evening, everyone. Welcome to the special immigration show brought to you by Sakshi TV. My name is Ranjit. We are here today with prominent attorney Ms. Sheela Murthy to discuss the latest updates, frequently asked questions related to H-1B and green card. You can call the numbers displayed on the screen and ask any question related to immigration, and our attorney will be glad to answer. We will start taking calls in few minutes. Before starting the show, I would like to repeat the disclaimer. Please note this show does not provide any legal advice. It is general in nature and it is only for informational purposes. Sakshi TV news and agents are not responsible in any for your actions. Please use the information at your own risk. For case-specific issues or concerns, please reach out to attorneys for a private consultation. Hi, Ms. Murthy. How are you doing?
Good afternoon or good evening to you in India. It's great to see you again, Ranjit, and thank you for this opportunity.
Yeah, you all know Ms. Murthy is the founder, president, and CEO of Murthy Law Firm, and she's a Harvard Law School graduate. Also, she's the one behind the famous Murthy.com website. Before getting into the show, could you please briefly introduce yourself, Ms. Murthy?
Sure. It's a pleasure and honor to see many of you again today. As many of you know, the law firm, Murthy Law Firm, was started almost 30 years ago. And the website, Murthy.com, has lots and lots of valuable, free, cutting-edge information that you all can take advantage of, whether it is the weekly Murthy Bulletin, the weekly chat, the forum, the questions and answers, the articles, the Murthy teleconferences that we do each month that we post with the link to help each of you learn the law, understand the complex nuances and the things that are changing, and any updates of meetings or discussions that we have with the government, latest rules that happen. We share all of that with each of you so that you are kept abreast of the latest changes. With that, I guess we can discuss any updates or any questions that any of you have. Right, Ranjit?
Yes, Ms. Murthy. Before getting into that, we have a caller, Balaji, who is on the line from California. He is very impressed with the show and he just wants to probably ask a question. Hi, Balaji. Welcome to the show. Please go ahead and ask your question.
Balaji, are you there? Please go ahead, unmute yourself.
Okay, we have another caller, Nag. Let's take the call. Probably Balaji got disconnected. Hi, Nag. Welcome to the show. Please go ahead and ask your question. Hello. Can you hear us, Nag?
Yes, I can hear you. Thank you, Sakshi TV and Ms. Murthy, for doing this. I really appreciate it. Here is my question. So I have a I-140 approved from my previous employer under EB2 category with a priority date of June 3rd, 2011. I moved to a different company and POM is approved recently. My question is, as you know, EB2 category priority date is June 1st, 2011. So it may get current next month. So should I wait and file under EB2 category, both I-140 and adjustment of status, or I can go ahead and file under EB3 category, both I-140 and adjustment of status?
But in the EB3, you have to do it as a downgrade petition with USCIS, right?
Yeah.
So what you could do is wait and monitor, because you want to wait just 1 month. Why don't you wait? Because by the middle of each month, you get the visa bulletin information for the next month, generally around 10th or 15th. Nowadays, we have been seeing in the past 6 months, since last October, it has become towards later in the month. But if you know by the middle of the month that EB2 is getting current, then that way you don't have to take a risk and try for EB3 downgrade and wait for that to get approved. You can file the 485 with the current EB2 approval right away. And that way there's less risk, because you can enjoy AC-21 job portability within 180 days and all those other benefits. On the other hand, if there is no forward movement and your priority date does not become current NAG, then you would have to, I guess, take a chance and just file the EB3 downgrade and hope it'll move. We are seeing some EB3s taking few months, some taking many months to get processed. We're just starting to see some of the approvals from last year in October, which means it is taking USCIS almost about 7-8 months to approve these downgrade cases. We haven't heard of too many problems of denials on EB3, which is a good good place. And, in that sense, it's less scary than we were during the prior administration of the Trump administration, where they were looking at almost any and every excuse to try to either delay or deny an approval for legitimate bona fide candidates.
Thanks for the call, Balaj. I hope you got your answer. We have another caller, Nag, waiting on the line. Hi, Nag. Welcome to the show. Please go ahead and ask your question.
Sure, thank you. Hi, ma'am. Thank you for taking my call.
Sure.
I was
Thanks,
with employer A, and my priority date is September 2015 in EB2. In October 2020, I moved to employer B. In October 2021, if my priority date becomes current, maybe in EB3, so I'm planning to move back to employer A to file for I-485. And I spoke with my employer A, and my employer A not revoked my H-1B or I-140. So is it okay if I move back to employer A without having H-1B transfer? Because with employer A, I have H-1B until 2023 and apply for 485.
So if the prior employer A has not revoked the H-1 approval and they're willing to take you back, and everything looks like it could work out, and they want you to join them immediately in order for them to agree to file the 485 for you, then you could do so as long as you're deciding both business-wise, financially, and immigration law-wise now, then that it makes sense for you and your family to do that, right? Because the employer probably didn't revoke it because they were hoping for something like this. Because generally, most employers revoke the H-1B petition as soon as the employee quits the employment. So if they haven't revoked it, then according to USCIS, there's a very old Efren Hernandez memo from maybe 10, 15 years ago that actually allows you to go back and work with the previous employer based on the prior approval, even if there was a later H-1B approval by a new employer after that approval. The only catch, of course, is that then hopefully the second employer, your current employer, will revoke the H-1 approval, because under the last action rule, the USCIS could take the position that the current H-1B that is valid and that shows your status is the current latest approval or the latest action of the USCIS with respect to your status. So if you are going back on the prior one, request maybe the current employer to revoke the H-1 when you give them notice that you have to leave their employment primarily to pursue your green card options.
Oh, sure. So I have to tell my employer B to revoke my H-1B, correct, ma'am?
Yeah, that way it's a little bit cleaner for you, Nag. That way there's no question about under last action rule, is the correct H-1 for you the one with employer B and not with employer A?
Thanks for the call, Nag. We have another caller, Saujanya. Hi, Saujanya. Welcome to the show. Please go ahead and ask your question.
Hello, madam. Hi. I have a question. Recently, I got my H4 stamping done in India, and I'm back to country. So, how should I go about my cancelling, or what is the procedure now I should follow for my H4 existing application and my EAD?
So don't do anything with it because you went. Let's leave it as it is. They may come back with an RFE, Saujanya, asking, did you travel? What did you travel? Because if you do a change of status, then travel abroad results in abandonment of the current application. However, if you're doing either an extension of status or while the extension of status is pending, you go abroad, you get the visa and you come back, the USCIS is allowed to continue processing both your H4 extension of status, Saujanya, and the H4 EAD application. If you bring something to their attention, the risk is they may get a little confused and cancel the H4 EAD application, which already you have waited 6 months, 8 months, 10 months. You don't want to lose again 8 or 10 months without work authorization. So I would do nothing because you were legally permitted and allowed to go abroad to apply for the visa, to come back on H4, and the extension of status can continue to get processed by USCIS And if that gets approved afterwards with the EAD, fantastic. If they issue an RFE, tell them that it should not impact USCIS continuing to process both the H4 extension of status for you and the H4 EAD for you, Saujanya. Good luck. I hope it works out.
Thanks, Arjuna. Thanks for the call. We have another call, Mr. Rao. Hi, Rao. Please go ahead and ask your question.
Thank you, Ms. Murthy, for taking my call. I have a question. I was with employer A and I quit employer A in 2017. My employer A did my form and filed my 140 in EPT. And from, I think, 2018 and 2019, in the ability of pay, he did not show my 140, but he had enough funds to support me, which means whatever my salary was, he had enough funds in the tax returns. Now in 2020, when the dates were current, I went back to my employer A, and he downgraded and filed it in EB3. Now, would there be any kind of issue because he did not show the ability of pay in 2018 and 19, though he had sufficient funds in his tax returns?
So it could come up, as you well know, Mr. Rao, by USCIS issuing a request for evidence or RFE on your case, asking the employer for proof of the ability to pay in 2018, 2019, and 2020, when you were not working for them, because the employer has to show that profit or that difference of your price salary in their tax returns of the entity. It could come up or it may not come up because the employer had already satisfied all that, gotten the EB2 approval, and now we are focusing on the EB3 downgrade with your 485 filing. We have not seen too many issues with ability to pay come up in the EB3 downgrade cases so far. So hopefully it won't come up in your case also, Mr. Rao. But if it does come up, then hopefully the employer can show their financial ability and their proof and their financial wherewithal, and that they will be able to meet the ability to pay in your particular case for your EB3 downgrade petition. Good luck. I hope it works.
Thanks, Mr. Rao. Thanks for the call. Ms. Murthy, yes, we were talking about the updates. Could you please give us the latest updates, that's important to the viewers, and then we can go ahead.
Sure. So I know we talked a whole lot last week about the latest changes that were happening with the Department of Labor, Department of State, USCIS, Homeland Security. I think we talked quite a bit about CBP. We didn't get a chance to finish. We had to stop because the time got over. But CBP is willing to look at cases on an individual basis. They will also you can contact the airline passenger advance information to ask them to get prior permission from CBP if you think there's a gray area for people who have been outside, for example, as a green card holder for more than 1 year abroad, and the green card is considered abandoned, but you can explain due to COVID-19, you couldn't travel, or people coming in on the H-1B or as spouses of citizens or green card holders trying to find the exception or proving why and how you qualify based on extreme humanitarian reasons or economic benefit or health reasons to help, fight against COVID-19, all of those factors. We talked a little bit about that. Also, some of the latest changes, the visa bulletin was just released, and as you know, last week, within the last week after we had our last week's call, and priority dates have moved again. Final action dates, of course, are what you have to look at for employment-based cases this month. And a lot of people who did not file in October and November last year, because they were either traveling abroad or their family members were traveling abroad, but who are now in the United States, can use this opportunity to file the 485 or the downgrade cases or just the regular EB2 cases, so that at least you can file the 485 with the EAD and AP in order to be able to enjoy the benefits of AC-21, adjustment of status portability, where the I-140 is approved and the 485 has been pending for more than 180 days. Charlie Oppenheim, the head of the Immigrant Visa Control Unit for the U.S. Department of State, who is primarily responsible for movement of immigrant visa dates across the world, has explained that he expects a lot of the unused immigrant visa numbers in the employment-based category to continue to move quite rapidly. And because of the huge number of filings in EB3, they expect that EB3 will actually move a little bit slower than EB2 moving forward. So that's why EB2 is starting to move a little bit, and EB3 isn't moving as quickly right now because of the number of EB3 downgrade cases that have been filed. And even though USCIS has not yet approved majority of them because they're still pending, they are starting to change the category on many of those cases from EB2 to EB3, so that they now know how many, allotment of EB3 cases will be expected. So that's something Charlie Oppenheim talked about, both at the ELA conference and at the meeting that we had, and in the visa bulletin. It's been explained, I believe. So there's a lot of things going on, but of course, as with immigration law, as Ranjit and you and we all know, what we discussed today may not be relevant tomorrow, because sometimes there's just so many exciting things happening on a daily basis. Thank you.
Thanks, Ms. Murthy. Thanks for all your advice and information. We have Rao again. Probably he wants to ask another question. Hi, Rao. Please go ahead and ask your question.
Yeah, thank you very much, Ms. Murthy. Sorry, I wanted to ask a follow-up question. So since I did not upgrade my EB3 to premium, do you suggest I should do that or wait because my final action date is correct at the July bulletin?
So we've seen people where they've said that the EB3 case, the downgrade case, they have done premium processing and the USCIS has approved it. We have also seen and heard of other cases where USCIS is not allowing the EB3 case to get premium processed because according to USCIS policy, Mr. Rao, the employer is supposed to include the original labor certification in order to be able to enjoy the benefits of premium processing, of the premium processing program. Since obviously the original labor certification is with the original EB2 that was filed, technically the USCIS is not allowed to or supposed to approve the EB3 downgrade under premium processing program. But we have been hearing people are doing that all the time and they're getting approval. So if you don't mind losing the money, you could try the premium processing and USCIS may agree to do it, or they may say, I'm sorry, we cannot do it. And they may refund the money or they may not refund the money. So you could end up losing $2,500 without getting the benefit of premium processing. So that's the main risk in this case, though we are hearing about it getting approved, which is fascinating because it makes sense on one hand, because the USCIS does have the original labor certification with that original EB2 case that had been filed by the employer previously. Discuss it with the company and the lawyer as well, just to see what they're comfortable doing for you, Mr. Rao.
I'm very comfortable doing it. It's just my call. I just wanted to take your advice on that. Thank you.
Yeah. Good luck. All the best.
Thanks, Rao. Thanks for the call. We have another caller, Ashwin. Please. Hello.
Hello. Hi.
Yeah.
This is Ashwin. Hi, ma'am. I have a question regarding expertise requests for H4 and H4 EAD. Last October, we went for the downgrade EB3, but as of now, we didn't get any update on that one, like EAD or AOS EAD or biometric. But my wife is using right now H4 EAD, and it is going to expire in July in month. So we went for the local congress for the expedited request for AOS EAD twice with all supporting documents, but it was denied. And now H4 and H4 EAD we submitted in February month in 2021, but as of now we didn't get anything. So is there any option to expedite for H4 or H4 EAD simultaneously, or what are the steps do we have? Because she may lose the job if she won't get any EAD, AOS EAD or H4 EAD. So any suggestions?
Yeah. Did you say you applied for the H4 EAD in February of 2021, but the AOS EAD last year, October, November of 2020? So we have seen that the 485 EADs are actually getting approved sometimes a little bit faster than the H4 EADs, because I think the prior administration was trying to make it much more difficult for H4s to get approvals. That's why that had been backlogged between 8 months and 13 months for H4 EADs. But 485 EADs, if you already had the biometrics, and because you don't have to get biometrics in every single case because they already have fingerprinting and other security information for most non-immigrants because of your travel and other reasons. So that could get approved. We are seeing that they're denying most expedite requests unless you can prove severe humanitarian and other harm, because I think they're afraid that thousands and thousands of people will then request them to do the expedite, and they are just so short-staffed partially because of COVID-19, partially because their own making and doing by purposefully putting roadblocks and steps to delay and deny cases. That has caused them such a heavy backlog in processing H1B and H4s and H4 EADs. You can keep trying. Now, people who have even sued haven't been successful, Ashwin, because the judges have been like a little bit, I think several law firms and AILA and other lawyers have tried filing lawsuits on H4 EAD delays in issuance, but it doesn't seem to have helped getting it any faster anyway. And even the judges have said, hey, how are they supposed to do the work if they can't get around to it? So there's no guaranteed way to do it. I know some people travel abroad, as we had our first scholar talk. They travel, get the H4, come back, and then let the EAD continue and hope that because now they're already on H4 status, the EAD can be approved faster. But there is no real magic solution. Even lawsuits have not automatically been proven to be successful like they were in the beginning, when we were finding that when there were very few lawsuits, they were the government was approving those particular cases or pulling them out of line. But now they are just getting so many lawsuits, so many expedite requests, so much pressure, and they're short-staffed and all of that they're not even concerned about it or bothering to respond to expedite requests. So it is a big problem. I know it's a big problem because this is your life, your livelihood, your ability to pay your mortgage, to pay or make your car payments. It's a shame. It's a tragedy that this country has allowed this kind of incompetence to occur with respect to people's lives and livelihood. And the fact that they're not doing it as expedites or agreeing to it, when one of the criteria for expedite is severe financial loss to the employer or to the family members, it doesn't make sense. But even the courts are not siding with individuals in this situation, with the H4 applicants who are suing.
Thanks, Ms. Murthy. Thanks for your advice. Going back to our questions. So yeah, one question a lot of people have in mind is, what is the difference between withdraw and revoke? A lot of people use these two terms, revoke, withdraw, and some people say revoke can only be done by USCIS, not employer. Can you just give a brief of what that is?
Yes. So it's true that a withdrawal request is generally done by the employer or the employee, saying, generally employer in an H-1B petition or in a 485, and it's an application filed by the individual, you can say, I no longer wish to process the case, please withdraw my application. By law, a withdrawn application is considered as if it was never filed in the first place, because you're withdrawing it effective from the date of the filing. Now, revocation could be in a couple of different scenarios, right? The employer can request revocation of the H-1B approval after the employee quits the employment or is terminated or leaves or whatever. And then the USCIS sends the confirmation of the revocation to the employer in an H-1B or I-140 scenario, where the USCIS can revoke it. Now, USCIS can also on its own, sua sponte, as they call it, revoke the H-1B or the I-140 petition, etc., if they find there was fraud or misrepresentation either of the employer or of the employee. So yes, generally revocation is used where the USCIS or the government agency revokes or cancels out the prior case that was already approved. In a case of a withdrawal, it's usually the employer or the applicant that requests USCIS, please withdraw my application because I no longer wish to pursue it, or you approved it, now I have quit that job, please revoke, please withdraw my once it's approved, it's a request of revocation. Withdrawal is generally when it's pending. So it's again another subtle nuance inside the nuance. But it's true that with respect to fraud or misrepresentation or material fraud, USCIS is allowed to revoke anytime, even after the I-140 has been pending over 180 days, because they reserve that right under their regulations. We hope this was helpful.
Thanks, Ms. Murthy. We have a caller, Harinath. Let's take the call. Hi, Harinath. Welcome to the show. Please go ahead and ask your question.
Hi. Thank you, Ms. Murthy and Sakshi TV for taking my call. So my question is on H-1B. My I-485 is in process. So we are buying a house in Seattle. My agent agreed to pay part of his commission back to us. So he said he's going to issue 1099 on our name. Can H-1B get this 1099? Is it legal? That is one of my questions.
So I obviously can't give advice on tax-related issues, Harinath. But in general, if you are an H-1B, that means you are an employee, because one of the things we explain to the Department of Homeland Security and U.S. Citizenship and Immigration Services, to the USCIS, is that Harinath is an employee with an employer who has a right of control, etc. So 1099 is generally given for an independent contractor who is working without an employer-employee relationship. Probably the reason why your broker is trying to get you a 1099 and not show you as an employee is because if you're called what's called a foreign person, it's called the FIRPTA, F-I-R-P-T-A, under the foreign person's representation. If you're not a US citizen or a green card holder, the seller can withhold 30% of the purchase price of the property to pay in taxes for the property. Or it's generally when you're selling. In your case, if you're buying, it should be less of a problem because you're purchasing the property. But I wonder, I'm not very clear why the broker wants to do it. But if it's about FIRPTA taxes or some other taxes, it can be problematic because H-1Bs are not allowed to be 1099 or what's called 1099 or 1099 independent contractors, because you have to show that you are an employee in order to be eligible for the H-1B petition approval. So you don't want to be caught between a rock and a hard place or, do something that's improper.
1099 just to pay off his commission.
Oh, he's going to give you a 1099 to pay off the commission. Well, he can't give you a 1099. You should request that it be shown as a credit on the settlement sheet. Don't show it as a 1099 payment. Tell him to issue it as a credit against the payment of the purchase price. So he gives it directly to the seller, because if it comes to you, then if it's income, you'll have to pay 30% or 50% federal tax on that money. So if he gives you 10,000, you'll only get 5,000 in your pocket. 5,000 will go to IRS for taxes. But if you're able to show that he's giving a credit towards the closing costs by sacrificing his commission or her commission to help you, then let them show it on the settlement sheet. I'm going about what I'm supposed to do as an immigration lawyer. This is not an immigration question, Harinath, but I would request the broker to please do it directly on the settlement sheet and not to give you a 1099, because 1099 means income and it's a violation of your legal status, because as an H-1B worker, you are not allowed to work for another person and get a 1099. That is a violation of your H-1B status.
I hope you got your answer. Again, Ms. Murthy, a lot of people have a lot of questions about these, downgrades and, how USCIS is going to use the numbers, or if they are going to use the numbers or what. Do you have any information from the last meet that how they are going to count the numbers? Because a lot of people filed in EB2, EB3, they count the number when it gets current, or, a lot of people also interfile. How is this thing actually going to work?
So when they issue the receipt notices, like in the EB3 downgrades, they're supposed to start noticing how many cases they have in EB2 and EB3. Now, one of the things that USCIS has said to us, with including their senior, including Alejandro Mayorkas, when he talked to us, is how overworked they are, how short-staffed the USCIS is, how they're struggling. in my mind, part of the problem is created by themselves by being slow and incompetent, but part of it is there's been a lot of filings, and because of COVID-19, a lot of people haven't been working. So how are they monitoring it? They don't give us all of the details, but they are supposed to monitor how many EB2 and how many EB3 applications there are based on the receipt notices. The problem with the downgrade is that the original receipt notice still shows it as an EB2, but now the new filing shows it as an EB3 receipt notice. But in the end, they're only going to issue one out of the two, not both of them. But in their records, it shows as one EB2 and one EB3, because that's their system is sort of not very, I don't think they planned on every nuance and every complication on how to count numbers. Now, the big problem, of course, is we only have so little time before September 30th of this year. It's already middle of June. And so you only have July and August and September. We have only a little over 3 months left. And if they don't use up all the immigrant visa numbers that have to be exhausted for this fiscal year, the extra will roll over to next year. But again, this is what causes more and more and more backlog. So when people say, can the USCIS guarantee it, can be assured, what can you do? The government keeps increasing the fee. They keep charging more and more, but they're not accountable. They're not giving us any real concrete information. And some people are suing, and those cases that sue sometimes are pulled out of line and processed. But even that, they have started fighting and pushing back because so many thousands and thousands and thousands of lawsuits have been filed against the USCIS for delays, by writs of mandamus, for procrastination, for H4 EAD delays, all of those that we talked about earlier in this discussion as well. So when you ask the question, how do they do it? They don't sit down and give us exact details, but they have said that there is an overwhelming amount of work. There's a shortage of staff. COVID-19 has exacerbated the problem, and that they're trying to do their best, and that getting EB2 and EB3 cases for the same person is adding confusion to an already overworked and understaffed organization. So I don't know, maybe a lawsuit would be required, because I remember when we used to sue the government or ask them, how do you count how the 65,000 H-1B numbers are counted, or the plus 20 for the master's degree quota? They don't have a system. And when somebody is revoked after it's approved, when the employer revokes it, they used to argue the person is not counted against H-1 and counted. I think there's so many gray areas under the law. It's really scary. As they say, if you look under the hood of how they do the processing, you may get so scared and nervous that we are relying our lives upon this agency that I'm not sure that all their ducks are in order, because the rules have been changing so dramatically with regulations between one administration and the next, adding to all of the complications.
Yes, thanks, Ms. Murthy. We are towards the end of the show. You are past time. Again, thanks for all the calls and watching the show, audience. It was a great session with interesting topics and questions. Please call in every Tuesday at 3 p.m. EST to watch the special immigration show with Ms. Murthy. Again, it's every Tuesday, 3 p.m. EST. This is Ranjit signing off. Thanks, Ms. Murthy.
Thank you. Bye-bye.